I want to tell you something that might be a little unsettling. The artificial intelligence tools you're using right now to run your business, to write your marketing copy, design your logo, generate product ideas, create images for your website, draft your emails, produce your social media content, those tools are raising intellectual property questions that most attorneys, let alone most business owners, have not fully thought through yet. And here's what makes it genuinely spooky. The wrong assumption can cost you your copyright. It can sink your trademark application. It can leave you building a brand on a foundation you do not actually own. I've been scrying into the crystal ball containing the mysteries of the relationship of artificial intelligence and intellectual property law for a long time. Briefly, my programming and legal tech background started last millennium, and I did my master's degree work on AI and natural language processing before the LLMs got in the game and changed everything. So naturally, I've been paying close attention to how IP law intersects with AI use. The Copyright Office has now issued three major reports on AI and intellectual property. Federal courts have weighed in on some key questions. The USPTO has issued formal guidance on AI and patents. And the questions are practical, consequential, and directly relevant to every small business owner who's using AI tools in their work. I'm Julie King of King Patent Law PLLC, a patent attorney, business attorney, and lifelong horror and rock music enthusiast. I have a particular talent for identifying the very real legal monsters lurking in places most people are not looking and letting people know how to avoid their claws and fangs. Right now, there is a significant amount of misinformation, oversimplification, and frankly, some genuinely problematic guidance circulating about what AI does and does not mean for your intellectual property. So let's fix that. Here's what we're covering this week. What the U.S. Copyright Office now says about AI generated works, whether your AI prompt makes you the author of the output, and the Copyright Office has very clear answers on this, what AI means for trademark protection of your logo and brand name, what USPTO guidance says about AI and patents, what training data and fair use means for your business, and a newer issue affecting anyone building a personal brand, digital replicas, and why the Copyright Office is calling for new federal law right now. I have a companion episode for lawyers and others who want to peer deeper with me into that crystal ball of AI and IP coming out next week. Avoid the legal horrors and keep rocking your IP. If you're ready to think through how AI use in your business affects your IP strategy, book a consultation at kingpatentlaw.com. This episode contains attorney advertising material. My law firm address and other contact information is in the show notes and the bio and available at kingpatentlaw.com.